always don't lie. We fought for our freedom with guns by our side. Red, white, and blue, our southern pride. Raise the flag high, let freedom ring from the rolling mountains to the flatlands. We sing, no one can take our rights. Our Second Amendment will defend our land. With every bullet we stand. We were born in the USA, land of the free, with guns in our hands. We'll forever be Southern blood runs deep through our veins. We'll stand tall for America till the end of our days.
Well, hey there. I'm Sully, and as always, welcome to the Gun Club. Hope everybody is having a wonderful day. I hope everybody had a wonderful Christmas. I hope everybody had a happy Hanukkah, or whatever you celebrate. More power to you. We're live tonight, December 26th, on YouTube, live on Rumble, and of course, even live on Mr. Musk's X, or Twix, or Twitter, or whatever we're going to call it. We're triple streaming tonight because, hey, we got something to talk about. I wasn't sure if I was going to get this show on tonight. I've been trying to do a lot of extra content over the holidays while some of the big boys are on vacation. Hey, they can afford to go on vacation. Some of us working stiffs actually had to work. I worked yesterday. We're in the city, and we earned our pay yesterday. I'll say that very publicly. We definitely earned our pay yesterday. Went out about every 2 hours for 24 straight. I got so tired. Picked up coffee and breakfast on the way home. Got home, brought the breakfast in the house, left the coffee sitting in the car. Realized the coffee was still sitting in the cup holder in the car, which it still is right now, and didn't give a shit. So, yeah, that's kind of where I was. So, it's been a rough couple days. On the other side, I hope everybody had a wonderful Christmas. Hope everybody had a wonderful time with family, with friends, whatever. I saw some really cool Christmas trees, or gunmas trees, as we will call them. This was one that came across my feed, and I thought I'd share it. Yes, that's right. Wishing everybody a very, very Merry Gunmas. Yes. Oh, look at that pretty little AR sitting there, all decorated with a star on top. Now, that might be okay for a single guy, but what if you have a family? What if you've got more people in your life? Well, maybe you'd have a gunmas tree that looks something like this. Ah, yes, freedom and the Second Amendment. A beautiful gunmas tree there. Set up, decorated so nicely. Wonderful, wonderful. And for the single ladies, just remember, sometimes you can get just the right man, and yes, he went to Barrett. So, it's okay. I know you'd love to see him slide down your chimney with that beautiful piece of hardware right there. And so as to not leave our chosen friends in a lurch, because yes, we support our chosen friends as well. This one in from Yehida Remmer, formerly known as the Pew Pew Jew, celebrating Hanukkah. So he's gone ahead and lit off his menorah there. Yep. Celebrating the wonderful Hanukkah tradition with Yehida Remmer, the Pew Pew Jew. Tonight, we've got kind of an interesting story. We're going to be sort of following up, which may be the last update. I don't know. We never know when it's going to be over. Some of these stories they keep on giving. We're going to get into Alec Baldwin, the latest updates. Now, we're going to recap real quickly. If you're not familiar, you've been living under a rock and haven't been following the channel, well, what's wrong with you? But beyond that, we know that back in, it was October of 2021, there was a shooting and subsequent police investigation at the filming of the movie set of Rust. Alec Baldwin was a producer. He was also starring in it as the title character, Rust. And he had a firearm that discharged. We'll just leave it at that for now. And this firearm that was supposedly unloaded, or so he thought, discharged, striking and killing cinematographer Helena Hutchins, going through and through her, and killing wounding Joel Souza, who was behind her. Now, everybody thought the gun was unloaded. It turned out it wasn't. It was loaded with live rounds. Live rounds don't belong on a movie set. You can go back over my Alec Baldwin coverage, the Screen Actors Guild policy, any firearms policy related to movies. You don't use live rounds on a set. And if you do have to, in a very limited circumstance, you sure as hell don't put a live loaded gun at another human being or anything. We know that. It's one of the 4 rules. We teach that. We say, no, okay, stop. Don't point a gun at anything you don't want to kill or destroy. Every gun is loaded until you check and prove otherwise. Keep your booger hook off the bang switch until you actually on target ready to shoot. Now, these simple rules, these big 3 out of the 4, if he had followed any one of them, Helena Hutchins would likely be alive today. He didn't. He broke every rule of gun safety. Now, they didn't charge him. They did charge him with manslaughter. They didn't charge him with premeditated murder. They don't say that he wanted to kill her, or he planned to kill her. There was a great, conspiracy to kill her. No, but manslaughter. And they charged him under a simple theory. He did something so recklessly. Again, if you're driving and you get into an accident, okay. But if you're driving incredibly recklessly, doing 75 and a 25 with a blindfold on, the likelihood you're going to hit something and have a really bad outcome, well, he did something very recklessly, i.e., handling a firearm. He took 3 of the 4 safety rules, actually the 4th, because the target and what's beyond it was not supposed to be Helena Hutchins. He took 4 of the 4 safety rules and shit the bed. So it would naturally lead us to believe that maybe he did something wrong here. I mean, I'm just grasping at straws. So he was charged with second-degree manslaughter. Now, there was a civil suit, and he settled one of the civil suits, and we can get into all that stuff. That's all about money. But the question was, what legal culpability in the eyes of the law does he have for doing something recklessly and taking a life in the process of doing so? If somebody is driving home from work and they are driving, I don't know, 70 and a 55, and they've got a bottle of tequila in the front seat and they're hanging out the window and they hit you, is that a criminal act? Well, if it's that reckless, yes, it may be a criminal act. So he was charged and pled not guilty back in 2023. And then the prosecutor who was prosecuting the case stepped down and they had to bring in another one. Then they dropped the charges against Alec Baldwin briefly. But when they dropped the charges, it was without prejudice, giving them leave to represent at a future date. Okay, so they represent. When they represent the charges, they went ahead. They had the gun investigated by the FBI, said there's no way this thing just went off on its own. Someone's finger pulled the trigger. They then had the gun again checked by an independent firearms lab, which is a well-respected lab. They came out with a report back in August of 2023, said, yeah, there's no way this thing went off on its own. So they're going to go to trial. Alec has always maintained he never had his finger on the trigger. Pictures showed otherwise. Alec has always maintained he was completely, it just went bang. No idea why. Well, okay. I don't believe him. I don't go with any of it. I think it's crazy. But, okay, that's his story, and he's been sticking to it. I'll give him that. Let's see. Okay, I see a couple quick questions in the chat here. I see Mary. Where do the live rounds come from? Great question. We will get there. I see Mr. Scott Awesome in the chat, sir. We actually sent Scott a special personalized invite tonight because we sort of scheduled this one at the last minute. Like I said, we've been trying to punch out some extra content. And like I said, I didn't even know we were going to be going tonight, if I was going to have time to do it or not. Quite frankly, I likely would not have had time to get everything together tonight had it not been for, well, my most favorite mouse of all, Minnie Mouse. She did a bunch of work today trying to get stuff together because I told her what I wanted to cover, but I also told her that I was up the better part of all night. And so, therefore, I spent a large amount of time this afternoon checking my eyelid for pinholes. Um, that's okay. Bro, I was looking earlier today trying to figure out what day of the week it was. Yeah. Um, Listen, I forgot my coffee sitting in the front seat of the car this morning, and it's like it's still out there, and I didn't care. I finished my little sausage sandwich, wolfed it down, and like walked in face down in the bed, and I was done. Minnie was nice enough to invite me to take me out to dinner tonight, and I was like, "Yeah, no, I'm not gonna do it." Um, I was asleep when she called, and by the time I got functional enough to answer her, she had already ordered food. And I was like, yeah, besides, I'd have to actually put on clothes. Folks, it's been like a ratty EMS t-shirt and sweatpants day. Um, very comfortable, just sort of sitting here, falling asleep, pulling the blanket over, and just dying in the chair right now. But so anyway, getting back to this, the trial began, and it began back in July, early July. And there was a prosecutor, Carrie Morrissey, special prosecutor, brought in by the DA's office to deal with this. Well, shortly before this all happened, in March of 2024, Troy Teskey, who is good friends with Thal Reed, who is the father of the armorer Hannah Gutierrez Reed, brought some ammunition to the sheriff's office. Now, I want to go through the timeline here. Shooting October of 2021. Ammunition brought in March of 2024, right before the trials are supposed to start. Dealing with all this stuff. Troy Teskey brings in some rounds. These rounds are indisputably were not in the state of New Mexico the day Miss Hutchins was shot and killed. There's no question about that. They were of a batch that was similar to the batch, or the same batch possibly, as some of the live rounds that may have ended up on the shooting scene. Now, I went through earlier the theory of the crime, why Alec Baldwin was prosecuted. It wasn't prosecuted because he brought the live rounds. It wasn't prosecuted because anything to do with the origin of the live rounds or how they got there. They really don't care about that. The theory of his prosecution was solely he handled something which is considered dangerous, a firearm, not a prop, a very real live firearm that, by the way, he, as a producer, had insisted on using live firearms, not a prop, not a plastic gun. I mean, when I do streams, I've got my little toy gun here. Yeah. If I've got this on stream, this is not a real live firearm. It's a great little demonstrator, and it's one I use in the classroom, but I mean, come on, it's a plastic child's toy. Now, it's cool because you can actually show how to clear a magazine and clear jams and everything else on it. But this is in no way, and again, if you touch it or handle it, it's a child's toy. So, from that standpoint, Alec Baldwin did not want plastic guns or plastic guns painted black. He wanted real firearms, wanted the realism. Okay, fine. Doing that comes certain inherent issues. You're handling live firearms. Yeah, that's why I use this one to pass around in the classroom, because we don't have accidents. We prevent accidents. We don't take live rounds in the classroom. We check and double check. We have our safety officers checking. Well, Alec wanted real firearms. Somehow, live ammo got on the scene. There's questions. Some people say Hannah had brought it for training purposes because they do train with the firearms, with live ammunition, to learn how they're supposed to behave so they can react appropriately in the movie. Some people say it accidentally got swapped in a batch. However, it got there, Mary, and we don't really know. We've got some hunches. Live rounds ended up on the scene, number one. Number two, you can tell very easily the difference between live rounds and dummy rounds. There's a couple of tests you can do as an armorer. I've worked on movie sets before, not in an armorer's capacity, but I am familiar because as the set medic, we went through the safety brief with everybody that they did prior to doing anything with a firearm. And they showed everyone in the safety brief how you can tell it's a live round. That's sort of something you do. Screen Actors Guild, safety brief, stunt group. Yeah. Well, they never had safety briefs on the movie either. Oops. Who'd have thunk it, right? So they come up to trial for Alec. The third day of trial, they're going over a bunch of the witness testimony, and it's very, very dry. And they've got the ballistics people there and the lab people there. And suddenly, the defense starts mentioning a lot about the rounds that Troy Teskey had dropped off. How do they know about those rounds? Now, technically, again, legal point, and Minnie, you can correct me if I'm wrong because she's our legal in the chat. If any information or evidence that comes to the prosecution that may be exculpatory or tend to prove the innocence of the person who's accused, they are required to turn over to the defense. So, if you're being charged with robbing a store and someone comes in and says, they couldn't have robbed that store. What makes you say that? Well, because the night the store got robbed, they were staying at my house down at the lake. They were drunk as a skunk. They passed out at 2 a.m. I woke them up at like 8:30 in the morning. They could barely stand up. There's no way in hell they robbed that store across town at 4 a.m. That statement, because it's exculpatory, has to be turned over to the defense. They can't hide that. Yeah, I didn't mean it like that, Scott. I know what you're saying. I definitely did not mean it like that. But yeah, we won't talk about him on this channel. I have no use for that idiot. But so anything again that the prosecution finds out that proves the person may be innocent, we have to turn over. Minnie, I was saying that as I explain this, you're welcome to jump in and tell me I'm wrong at any point because you're the resident legal eagle in the chat. And Scott mentioned a streamer by the name of Legal Eagle, and we're not going to talk about that idiot tonight. You're like, don't make me go into Tom. Oh, God, man. Oh, bro, you hit me sometimes. But under the court rules, if the defense finds out something that clearly shows their guy was guilty, they don't have to turn anything over. They are not held to that same standard. So let's say the defense finds out, again, robbery of the store, that, you were seen on a camera a block away from the store that was robbed. They don't have to take that video evidence and send it across to the prosecution and say, look, our guy was right there. They don't have to do that. But if the prosecution or the state finds out that, someone came in and said this guy was drunk, passed out across town and could not have physically left, we have to turn that over. It's part of making sure that the accused gets a fair trial. Well, these rounds that were dropped off in March of 2024 by Troy Teskey got to be a very big sticky wicket. Part of the reason was he went by the sheriff's office. He dropped off the rounds, turned them over to one of the forensics people. We turned them over originally to the front desk officer who called one of the lab people. They wrote a report that On this date, 3/6/24, Troy Teskey turned over the following. They logged it into evidence. They assigned it a case number. They assigned it a separate case number. They didn't connect it to the Baldwin case. Carrie Morrissey was made aware of them. She looked into it a little bit, and to her, and again, this is a decision, and we'll talk a lot about this decision because it's a big one. She made the decision that these rounds were not exculpatory. They were not related to the case. Now, is that the right decision? Well, the judge said no, it wasn't. The judge said that she should have notified the defense about Troy Teskey turning over these rounds and let them examine them and do whatever lab mumbo jumbo they want to do with them, because somehow that related to the case. Carrie Morrissey said she didn't think so. And we're going to go into, because once the judge ruled that Carrie Morrissey had violated Brady, which is the statute, the rule, the Brady rule, once they ruled that she had violated that, that is why Alec Baldwin's charges got dismissed, because she broke the rules. Okay. Now, her not turning this information over and making a notification to the defense of this, again, is a judgment call. It's a very big judgment call. It's 50-50, quite honestly. I personally, I'm not an attorney. I am a gun guy. I think the existence of these rounds and the logos and the brass and the type of primers on these rounds and the fact that this was similar to what was on scene, none of that bears any whatsoever, any bearing. None of that means anything regarding, did Alec Baldwin have his booger hook on the bang switch? Yes. Did Alec Baldwin point a gun at someone without checking to see if it was unloaded? Yes. Did Alec Baldwin cock the hammer on aforementioned gun while pointing it at someone with his finger on the trigger? Yes. They've got proof of all that. Where the ammo came from, to me, is like the least important thing. The judge, however, ruled that Miss Morrissey, Carrie Morrissey, had broken the rules. Now, I don't agree with Judge Summers' ruling, I'll say that. And I'm not some Carrie Morrissey fanboy by any stretch. But looking at it objectively, it doesn't matter if it was those rounds or some rounds someone picked up at the convenience store or something Hannah Gutierrez had brought to the set or something that ended up accidentally mixed up in something or other. A, he pointed the gun. B, he had his finger on the trigger. C, he cocked it. D, it went off. E, she got shot and killed. Where the bullets came from means nothing in that equation to me. So, when she failed to turn it over, in the judge's eyes, she committed this Brady violation. Brady violations are very bad things. Attorneys, especially prosecutors who hide exculpatory evidence, can get sanctioned, can get censured, can get their bar license cut up. Really a bad thing. I'm going to go through real quickly. The original thing came out and it was dismissed back in July of 2024. In October, Carrie Morrissey had thought about it a bit and decided she wanted to appeal the ruling. She felt the ruling was wrong, as do I. Whether y'all do or not, I don't know. But exactly as Mel points out so brilliantly, the Brady standard is that the evidence has to be exculpatory. Again, we'll go back to the, argument about the robbing the convenience store. If I come in and I say, hey, this guy was asleep on my couch, drunk as a skunk, there's no way he robbed that convenience store at 4 a.m., that would be exculpatory. However, if I go in and I say, look, I saw him 3 days later, and he didn't mention anything to me about robbing a convenience store, so clearly he didn't do it. He would have told me if he did it. Would that be exculpatory? No. It's a statement. may or may not mean anything. They may ask, well, has he ever mentioned robbing a store in the past? I talked to him 3 days after it, and he didn't mention having robbed a store, so he's got to be innocent. There's a real devoid of a connection there. And that's where Carrie Morrissey made this judgment call, and I don't fault her. I really don't. I think she got a really lousy deal. How that deal worked out, we'll get into because there's some questions also in my mind. Remember, Troy Teskey is very, very good long-term friends with the father of the armorer, Thel Reed. Thel Reed, much respect, sir. He is one of the original gunslingers, one of the original master shooters. He's right up there with, Colonel Jeff. He's right up there with the Moss. Thel Reed is a guru in the industry. His little girl tried to follow in his footsteps and maybe spent a little bit more time trying to be cool than trying to be good. Thel Reed was excellent, still is. Hats off to him. But his little girl is about to go for manslaughter. This is getting ugly. One of his best buddies comes in and leaves some ammunition at the sheriff's department office that may or may not be related. And when it doesn't get turned over, it's used to blow a trial clean out of the water. Now, if it was ruled that the ammunition didn't have to be turned over, trial goes on. If all of a sudden now this exculpatory evidence can be used to throw out trials, yeah. Would Troy have done this to help Thel's little girl? With Thel trying to be the dad, trying to, deal with Hannah. One more time, bro. Hannah, again, she's not a bad kid, I don't think, but she's also, she's a millennial. She's more of a borderline millennial zoomer. Yeah, I'm sure young Hannah gave daddy quite a time. And is Thel trying to do right by his little girl? If you did, bro, I respect it. I hear you. If you ain't cheating, you ain't trying. But it's weird that in a shooting from October of 2021, suddenly as things start getting go to trial in March of 24, someone shows up with some weird ammo out of the blue. They don't call a detective. They don't call the prosecutor. They don't go through channels. They just drive up to the sheriff's office, talk to the front desk officer, get someone from the lab to come in and just get a report to document it. Was that done to pull a panic button? Possible. Could Alec, having seen what was going on with everything, have talked to somebody and said, hey, look, if you do this, it might help get me off? It's really interesting and intriguing to me, and we're going to get into it a little bit, how the defense, by the third day of trial, knew all about these rounds, everything that was going on, and knew they weren't turned over. If they weren't turned over, how'd they know to talk about them? Just wondering. One of Carrie Morrissey's theories in her appeal was they knew about them all along. If they knew about them, there was no need for her to tell them about them. So, let's dig in. Let's look at her appeal a little bit because it is kind of interesting. We're not going to go through the whole thing because it's quite a few pages. On the other side of the coin, again, like I said, I thought it was something that was interesting because the way this case has played out, I've had people say, oh, Alec Baldwin was determined to be innocent. Innocent of what? He was not determined to be innocent of anything. It just basically the trial couldn't go forward because of the Brady issue. So that Brady motion was what shut the trial down. Now all of a sudden we're coming up to, Carrie Morrissey's appeal of that decision. It shows here again where she filed it back October 24th, 2024. She served everybody with it through the clerk of court's office, etc. And let's get into this. Order granting defendant Alec Baldwin's expedited motion for dismissal and sanctions Basically, they're trying to go over the original order, what happened. You know, he filed on July 11th, expedited motion. The state didn't file a response. On the 12th, the court entertained the oral argument by both parties. This is where they got into the discussion of she didn't turn it over. She says I didn't have to turn it over. And they go back and forth. During the evidentiary hearing, the court admitted evidence outside the presence of the jury. 5 witnesses gave testimony. Crime scene technician Marissa Papel, she was the one who actually got the rounds handed to her and did the report when he came and turned it over. Santa Fe Sheriff's Office Corporal Alexandra Hancock, Seth Kenny, Lieutenant Brian Brandel, Special Prosecutor Carrie Morrissey. She actually got on the stand and testified as to why she did not turn these over. At the conclusion of the hearing, the court granted the defendant's expedited motion and verbally explained its reasoning. The court entered the case order in furtherance, stating that basically they found a Brady violation on behalf of Carrie Morrissey and the prosecution. Therefore, the charges are dismissed and they can never be brought again. Damn. So, because of a procedural issue, yeah, this is that loophole or that, little thing that people get off on. They go through how he was charged, the scheduling order, everything. They talked about the pretrial litigation, going through the litigation of the case and scheduling. Again, very much the perfunctory stuff you'd expect to see. As we go through, let's see. On the 26th, the defendant filed Alec Baldwin's motion to compel disclosure and impose sanction. The motion concerned late disclosures, not failure to disclose, just late, made by the state in relation to some expert witness statements, and asserted that discovery issues relating to witness statements remained ongoing in the days leading up to trial. Again, anything that we're going to use at trial based on discovery, the prosecution has to turn over to the defense. If we have a statement from the store clerk that says the person coming in was 6'2" and 250 pounds, and your client fits that description, they have to be able to rebut that. So they have to know what they were using on the prosecution side so the defense can rebut it. If there's someone saying, oh, I saw a vehicle fitting that description, guess what? That has to be turned over so they can go back and look and say, well, how many vehicles could fit that description? They have to know what the prosecution's case will entail to give them a chance to rebut all the facts. Now, if something comes to light late into it, you can't ask someone to disclose something before they knew it happened. So a lot of this, again, comes through the motion to compel, late disclosures, asserted discovery issues relating to witness statements. They're trying to get all the discovery stuff together to get ready to go to trial. Co-special prosecutor Erlinda Johnson, who is a former federal prosecutor, disclosed over 1,100 pages of documents that Morrissey had previously refused to provide. Okay. Were they refused to provide? Were they things that mattered? Were they not? You have to remember, the original sheriff's department report on the shooting was in hundreds of pages. There was stuff that was hundreds of pages. I read through at one point the original shooter's report, and I do have it, and I think I published it over on Locals, where you have, one of the deputies wrote a report. I responded to the shooting scene. When I got there, they told me to maintain the perimeter. I went to the corner of the cactus and stood perimeter until relieved 7 hours later by Officer such and such standing the perimeter. Did that mean anything? No. So, did she fail to disclose something important, or did she just not kill enough trees? Remains to be seen. The court verbally denied the motion on the 8th after the parties represented that they would conduct a meet and confer to resolve the motion. So, okay, Alec's team is saying we don't have all the discovery. Carrie Morris, he says, what more do you need? We've given you piles of stuff. Well, they went ahead, said we'll meet up, we'll sit down, and whatever, we'll put our cards on the table. This is what our case is. This is what we're going with, which again, the prosecution has to do. That's fair. On the other side of that coin, do you have to disclose stuff that's not exculpatory, that doesn't matter, so to speak? They did not disclose where Hannah went to high school. Oh my God. Did it matter? No. They may not have disclosed what, Helena Hutchins had for breakfast that morning, because it probably didn't matter. So the court denies the motion. The parties agree they'll meet. On July 27th, the defendant filed a motion to exclude the opinions of Lucen and Michael Hagg. Basically, in pertinent part, the court denied the motion, saying that one contested disclosure was not late. Arguments addressing the other disclosures depicted arguments set forth in the previously filed motion. So they've gone through piles of this. Hagg, by the way, was the second lab that reviewed the gun. And their report was very much, this did not happen without his finger on the trigger. Ultimately, the defendant's filings demonstrate that the state continuously was making late disclosures to the defendant throughout the pretrial litigation and even in the days immediately preceding the jury trial. Now, why were these disclosures late? My hunch, you've got 1-2 attorneys dealing with this with a very limited staff, and you've got his dream team all dumping motions on them. If you've got 5 or 6 attorneys working in series to send motion after motion after motion at you, and you're having to respond, research, and argue all these motions, and also put paperwork together, you may be working 20-hour days. Is that an excuse? No, but it's a fact of life. So they get into jury selection. The trial court impaneled and swore 12 jurors on July 9th as we're going into the trial. On July 10th, parties made opening statements. 4 witnesses gave testimony. Officer LaFleur, who was employed by the sheriff's office, retired Lieutenant Benvenidez, Sergeant Lujan, going through, and crime scene technician Marissa Papel. Further, the court admitted numerous exhibits. The next day, Papel continued her testimony in the presence of the jury. Relevant to the order on cross-exam, the defense asked Papel about the ammunition that was submitted to SFSO, Santa Fe Sheriff's Office, by a Good Samaritan, Troy Teskey, near the conclusion of the trial of State versus Hannah Gutierrez. So it was near the conclusion of the previous trial. He drops by the sheriff's office. Hey, I got these bullets. Yeah, kind of weird. Now, asked about the ammunition submitted. They asked about them, but no one told them. I'm going back again. The defense asks the sheriff's office about the bullets that Troy brought on March 6th. But Carrie Morrissey never told them about them. That's why the trial got dropped. Anyone seeing anything kind of a little cringy here? They were never informed of those bullets. What? Huh, what? Yeah, so a Good Samaritan walked into the police station and gave you the lethal ammunition, didn't they? After the Hannah Gutierrez trial, there was an individual that came to the police station and stated they had ammunition. And they turned in the ammunition. Yes. And they gave it to you, right? Yes. Defense's questioning further intimated that these rounds were related to the Rust investigation. And they told you that this was the ammunition that ended up with Seth Kenny that killed Miss Hutchins, right? I do not recall all of their statements. Okay, but you didn't, He told you it had to do with the Rush shooting, correct? Yes. Defense's cross-examination further elicited testimony that the sheriff's office inventoried the ammunition, a supplemental report concerning the circumstances of the collection of it. Anytime you collect evidence, you document it, okay? Documentation of the ammunition in a non-rust investigation case number. They assigned it a new OCA or a new case number. I'm asking you, isn't it the case that law enforcement likely has the matching rounds to the ammunition that killed Miss Hutchins? I don't know. And you don't know because you made a doc report about this and you did not put it with the rest of the rust evidence, correct? Those rounds were not placed in with the rest of the rust evidence, correct? Nor were they sent to the FBI for testing with the rust evidence, were they? No. Now, again, this is 3 years or 2.5 years after the shooting. The ammunition shows up. The chain of custody on it is, who knows? And now we have them saying, well, you didn't send that to the FBI lab. Well, one of the rust cases is just closed. The other one is coming. We don't know where this stuff came from. I know what the complainant states, but it's sketchy evidence at best, folks. I got to say it. So, they weren't sent to the FBI with testing. No, they weren't. Defense further elicited testimony establishing the defendant was not given an opportunity to inspect the newly collected ammunition when the defendant inspected ammunition inventoried under the rust investigation. Are you aware the sheriff's office ever informed the defense that a good Samaritan had come in and turned in this ammunition? I don't know. Would the crime scene tech be the one in charge of this? Probably not. If anything, it goes to Morrissey, and Morrissey would notify. But when the defense came to view the Starline brass nickel primer live ammunition with you, you didn't show them this, did you? I do not have an evidence viewing with the defense. That was my coworker. Well, your coworker didn't show this to the defense, correct? I don't know. Do you have any reason to believe your coworker showed this to the defense, given that it wasn't even in the same inventory as the Rust case? No. No reason. On redirect, the prosecution identified the Good Samaritan as Troy Teskey, a close friend of Hannah Gutierrez Reed's father. In an effort to rebut the defense's cross-examination, Special Prosecutor Morrissey elicited the following. And it's really interesting as this goes through because, let me ask you, Ms. Popel, the ammunition that the Good Samaritan, Mr. Teskey, the close friend of Hannah Gutierrez Reed's dad, when the ammunition that he brought to you after her conviction, you still have it? Yes. You can bring it here and you can show it to the jury? Yes. And they can see for themselves it does not match the live ammunition from the set of Rust, correct? Yes. And it's obvious when you look at it that it's not. Yes. So it's obvious to the naked eye that the jury could see it doesn't even match the ammunition. Following testimony, defense alerted the court that their intention to file a motion regarding the state's failure to disclose the supplemental report and make available the Teskey supplied ammunition, the later delivery, for a defendant. Thereafter, the jury heard testimony from two additional witnesses, Alessandro Pieta and SFSO Corporal Hancock. The court recessed for the day amidst the state's direct examination of Corporal Hancock. So that was the extent of it. The lab tech says, yes, she got the evidence in, she logged it, she inventoried it, she looked at it. He said it was related to Rust. She logged it in a separate case number because to her, it was not collected on the Rust scene. It didn't look like the Rust ammo. It's logged, it's collected, it's in evidence. So, that's where we sit. Well, the morning of the 12th happens. On day 12, outside the presence of the jury, the court considered an argument by the parties on the defendant's expedited motion. The defense's argument primarily focused on the state's failure to disclose the existence of the supplemental report and the lack of opportunity to inspect the Teskey supplied ammunition. The state's arguments focus primarily on the purported provenance of the Teskey supplied ammunition. Prosecutor Morrissey proffered Mr. Teskey is Thel Reed's close friend, and Mr. Teskey stores Mr. Reed's ammunition. Mr. Teskey is a retired police officer who has a whole bunch of security at his property. So Thel Reed has 300 rounds of live .45 ammunition, and he and Seth Kenny are hired by producers for a show 1883. They get hired, they do what's called cowboy training on the set of 1883. So the cowboy training is where the gun experts, being Thel Reed and Seth Kenny, take the actors to shoot guns with real ammunition, kind of like I mentioned before. Further, Special Prosecutor Morrissey said when they originally went to the cowboy training camp in Texas, they didn't take all of Thel's ammunition. They took a certain amount of it, and Thel left some in Troy Teskey's garage. All of this ammunition came from the same place. It was all from the same batch that Thel Reed got from an ammunition manufacturer. Went on to say they take 300 of his rounds, they go to the cowboy training camp. 300 rounds for a training camp? That light week. I could do 300 rounds in a couple days at the range. But anyway, she elaborated that Thel Reed and Seth Kenny take 300 rounds, go to the cowboy training camp. He takes the leftover rounds back to PDQ. With respect to the Teskey supplied ammunition, the prosecutor further explained that during the initial investigation of the Rust incident, Mr. Teskey sent to Seth Kenny a photograph of sample of ammunition in the Mr. Teskey's possession. The photograph was sent to Corporal Hancock, and Prosecutor Morrissey also received a copy. The prosecutor proffered, when you look at that photograph, I'll blow it up for you, you can see these are not similar to the live rounds found on the set of Rust. Here's the ammunition. And again, if you're not familiar, ammunition has stamps on the case heads. It can be very, very specific, very, very unique. Prosecutor Morrissey says, I come into the case. I look at the ammunition that was taken. I understand from the witnesses the ammunition was sourced previously from Thel Reed. It was sourced from Hannah's dad. It's not a match. Not only is it not a match when you look at it, it's not a match when you send it to the FBI and conduct the chemical testing. The photograph that was sent to me is a photograph in the middle. That's not the same ammunition. You can tell from just looking at it. It has a different projectile shape. It's not the same projectile shape. It's not the same casing. It isn't Starline brass casing. It also has brass primers, not silver primers. All these differences. And they're trying to say this is related to the live ammo on the set that shot Helena Hutchins. Because if it's not related, it doesn't have to be turned over. So I agreed with Detective Hancock. This has no evidentiary value. And that's the big one right there. That is the decision that she made that led to this getting dismissed. It's a judgment call. I can't fault her on it. When it doesn't look anything like the ammunition, I mean, I can bring on set 5 kinds of 9mm ammunition that is all going to be different. And 9mm is fairly common. I can bring all kinds of 223 or 5.56 rounds. They're all going to look different. Brand names, markers, case markers, bullet shapes, lacquered round. She made the decision, basically, and that was what got her in trouble. That line right there. I decided that I could agree with Detective Hancock. This has no evidentiary value. As long as it has no evidentiary value, it's not exculpatory. It does not need to be turned over. Now, the prosecutor offered additional conclusions regarding the Teskey supplied ammunition. He argued that there is absolutely nothing about the ammunition Troy Teskey has any evidentiary value in the Gutierrez case, and it has no evidentiary value in the Baldwin case. None of this is exculpatory at all. Again, when we think of exculpatory, I'm going to go back to the, rob the convenience store theory. Getaway truck was a red pickup truck. Well, If it turns out that you owned a red pickup truck, but it was in the shop that week with the engine pulled out of it, that would be exculpatory evidence. If you were seen 3 days later driving a white car and had sold your red pickup truck, well, it couldn't have been him because he didn't even like driving that truck that much. That's not exculpatory. Well, he was looking to get a car. Well, if he still had possession of the truck at that time, it's not exculpatory. If you trade the truck in 2 days before, yeah, that would be exculpatory. After the argument, again, let's see, none of this is exculpatory. This is the exact same batch of ammunition that has already been sent to the FBI and tested because it all came from the same place. There's no reason to do it again. After the argument, the court conducted an evidentiary hearing, ordered that the Teskey supplied ammunition be produced for inspection, as well as the previously undisclosed supplemental report, regarding the collection of the ammunition. The first witness called was Papel, the crime scene tech. Before she gave testimony, the court reviewed the undisclosed supplemental report. Of crucial importance, the supplemental report documented that CST Papel collected from Troy Teskey 3 Starline brass 45 Colt with silver color brass casing. Okay. Further, the court asked CST Papel to identify the Teskey supplied ammunition that fit this description. The court visually inspected the ammunition. Thereafter, the court asked her, "Do you recognize any of these bullets to have been gathered on the Hannah Gutierrez on the Rust set?" She responded, "The Starline brass with the silver primer are similar to what was collected on the set." So, okay, they're similar. The second and third witnesses were Seth Kenny and Corporal Alexandra Hancock. Both the state and defense asked Seth Kenny questions about the ammunition once possessed by Troy Teskey, how some of that ammunition was used during the cowboy training camp, and how remaining ammunition ended up at Seth Kenny's business, PDQ. That was the one that supplied the ammunition to the set. Additionally, some of the defense's questions sought to establish a progressive trail to demonstrate the relevancy of the Teskey supplied ammunition collected by Santa Fe Sheriff's Office. Specifically, the defense's questions developed a timeline that 45 Colt ammunition was once possessed by Troy Teskey. Some of that ammunition was then possessed by Seth Kenny and Phil Reed. Seth Kenny then took leftovers of that ammunition to PDQ's business. Seth Kenny, doing business as PDQ, gave 45 dummy rounds with brass primers or brass casings and nickel primers to Sarah Zachary to go to Rust. PDQ again was the ammo and firearms supplier for the Rust set. Sarah Zachary then introduced those onto the set of Rust. She was one of the prop managers. Regarding the direct examination of Hancock, the state elicited testimony concerning how Teskey supplied ammunition fit within SFO's investigation of the underlying incident, why these rounds were not initially connected, and why the supplemental report collected were inventoried under the Rust, or were not inventoried under the Rust case number. During the cross-examination of Hancock, she testified that CST Papel gave false testimony during the second day. Specifically, Corporal Hancock testified that Papel's testimony given in front of the jury concerning attributes of the Teskey supplied ammunition when compared to the live ammunition collected from Rust was false. Do you remember the testimony that you were sitting here? Yes, I do. And it turns out to be completely false. Doesn't it? You're correct. Notably, Special Prosecutor Morrissey elicited this testimony through leading questions. Further, Corporal Hancock testified that once she became aware of the collection of the Teskey supplied ammunition, she, Special Prosecutor Morrissey, and Corporal Hancock's supervisors discussed and resolved how to address the Teskey supplied ammunition, i.e., do we inventory it and associate it with the non-Rust case number? The fourth and fifth witnesses were the lieutenant and then Carrie Morrissey herself. Lieutenant Brandle's testimony concerned the circumstances of the collection of ammunition. As far as the use of his body camera, he had to authenticate the video. Special Prosecutor Morrissey provided testimony to the court concerning the Teskey supplied ammunition. Again, whenever you hear Teskey supplied, the stuff that was walked in March of 24 from an October 21 shooting. Oh, it's related. It's got to be. Special Prosecutor Morrissey provided testimony to the court concerning the Teskey supplied ammunition and her understanding of its role within the Rust investigation. However, her testimony was internally inconsistent in part, conflicted with testimony given by one other witness. For instance, Special Prosecutor Morrissey testified to the Teskey supplied ammunition. So, if it never left the state of Arizona, the only way it's relevant is its similarity to the live rounds that were found on the set of Rust. Because we were at the point of trying to figure out the source of the live rounds. Yeah, they were looking for the source of the live rounds and how they got there. Backtrack, regardless of how they got there, what brass, what primer, anything. The elements of the crime that Alec was charged with was not ammunition manufacturing, ammunition trafficking, bringing the rounds to the set. The elements he was charged with was using a gun or handling a gun in a grossly reckless manner, which resulted in a fatality and another person shot. Does all this mumbo jumbo about the bullets really dig in? Yes, Mary, I'll agree. I want to know where the live rounds come from, and I think they need to, for safety's sake. But on the other side, I really kind of wonder how much of it weighs into the actual evidence of the shooting. Speaking of evidence of the shooting, I have a little bit of a palate cleanser because I knew tonight would be a little bit dry, a little bit boring, maybe. I knew that we could try to do something a little bit amusing or at least see something kind of interesting. This one came across my Twix feed today, and I thought you all might like seeing it. This did not happen in our country, by the way. It happened in a land far, far away. I'm not even really sure whose. But this being said, we're going to show you how not to handle a firearm when arguing with your neighbor about their music being too loud. This gentleman went out and confronted his neighbor about his loud music. Yeah, I want you to note there that the revolver he is holding is cocked and his booger hook is clearly on aforementioned bang switch with the gun pointed at his neighbor's stomach. Who wants to say that there's going to be an accident that happens here? Yeah. Folks, this is what not to do. This is what you don't do. A, if you cock that gun back, you cock that revolver, you've taken it from a double action long pull to a very light single action. So now, if Baldo here sneezes, guess what happens? This guy has an extra belly button installed. Yeah. And yes, it happened. On the other side of that coin, if you happen to be the gentleman there in the black and white sort of palm tree printed shirt, I guess it is, or whatever it is, bananas or, plantains, hell, who knows. If you are going to go toe to toe with a guy who has a revolver cocked and pointed at your thoracic cavity or your abdominal thoracic cavity, you're crazy. There is no way I'm going to start getting into a shoving contest with this man because, again, this goes just a little bit wrong and bad things start happening. And yes, they keep going at it because 50 Shades of Stupid just doesn't need to happen. Now, I would show you the rest of this, but YouTube would get very, very upset with me. So I'm going to link the video over onto our locals page. Folks, I wanted to bring this out so much just to show you bad firearms handling. Bad firearms handling results in bad things happening. And eventually I'll tell you that, yes, there is a bang here. And immediately the gentleman who is in the bald gentleman there is acting very surprised that this gun went off. He's very like looking at it like, how did that happen? About the same way that Alec Baldwin did. How did that happen? I've had it cocked and my finger on the trigger for half a day. How did that go bang? Yes. And Mel, I'll agree with you. It's not an accident. And again, this is not a US one. This just, I came across my feed and I was looking at it and I watched it. And the first time you watch it, you sort of chuckle at it and go, wow, I can't believe this guy charged a loaded revolver pointed at him. Then you go a little further and you realize that, yeah, this guy not only charged a loaded revolver pointed at him, the gun was cocked. And so, yeah, and the guy's finger is on the trigger. So, yeah, you're not, this is how accidents happen. Again, we try to be educational here. I bring this up not to make fun of someone for shooting someone or for getting shot. I bring this up to teach, to educate, to maybe provoke a little bit of thought, to inspire. Because you just don't see stupidity this good every day. But yeah, that one, I mean, I look at this and I'm like, this guy, you charged at someone with a gun pointed at you. Nay, nay, fluff, fluff. That doesn't work out real well for the home team. Number one. Number two, well, hey, I guess we'll all figure out how that works out. But hey, it's going to happen before too long anyway. Yeah. All right, let's get back to what we were doing here. Like I said, I just wanted to give us a little bit of fun, a little bit of a palate cleanser here. I see we're still streaming. We have got what we have running. Seems like we've got 10 on Rumble. We've got 1 or 2 on YouTube. And I'm trying to look and see how many we've got over in the Twitterverse here. I'm not used to streaming over on Twitter. So, folks, if you're in the Twitterverse and you want to say, hey, please feel free to do so. We'd love to hear from you. We do lots of regular videos here for the Gun Club, all sorts of firearms content. We do a lot primarily on Rumble, and we'll do a little bit on different options. We try to always put out informational, educational, and sometimes amusing topics. But again, I see we've got a few over there watching us in Twitter, so we appreciate it. Trying to broaden our spectrum, so to speak, have a little bit more fun, get our word out there, trying to grow the channel. So, folks, as always, we're trying to grow the channel. Please, if you'd be so kind, let your friends know, like us, share, follow the channel. The more we can do, more, I'll put it this way, the more interest we get, the more content we'll make. And I think everybody who knows me knows I enjoy doing this. This is a labor of love. It definitely can be a lot of fun. So as we're going to dig back in here to the rest of Miss Morrissey's discussion, because again, I think when you look at it at first, again, I heard that, oh, well, she didn't turn over evidence. She committed this Brady violation. And I know a Brady violation to be a really bad thing. And I'm like, what was it she didn't turn over? Again, if she had a statement about this convenience store robbery that no, so and so was out of town on business, he couldn't have shot his wife that night. We know where he was. He was on video in a convenience store 500 miles away. That would be exculpatory. If they say that, 3 months after his wife was shot, he said he didn't like guns. And that's loosely related at best. It really doesn't say a lot to us. So failing to turn that over, I don't think is this big Brady violation. My opinion, again, I'm not a lawyer, and far be it from me to say that the judge is an idiot. I'm not saying she is or she isn't. What I am saying is I think she might have missed the boat on this one. So, Special Prosecutor Marcy provided testimony concerning the Teskey supplied ammunition and her understanding of its role. Her testimony was initially inconsistent, in part, and it conflicted with some of the testimony given by another witness. So, if it never left the state of Arizona, the only way it's relevant to the Rust investigation is if it has any similarity to the rounds were found on the set of Rust, because we were at the point trying to figure out the source of the live rounds. Yet Prosecutor Marcy also testified the rounds that were left at the Sheriff's Department by Troy Teskey, I have no reason to believe they are relevant to the incident that took place on the set of Rust. These are rounds that were in the possession of Fel Reed and never left the state of Arizona. Okay. Whether they left the state or didn't leave the state or went to the cowboy training, I think we're grasping at straws here. Now, 36 was a big one. Further, during cross-examination of Prosecutor Marcy, so she's up taking the stand, the other attorney crosses her. You also did not allow the defense to view that Teskey supplied ammunition at any point during our request to review evidence. Special Prosecutor Morrissey said, I had never seen it. I didn't even realize it wasn't under the same case number because I'm not a law enforcement officer, which is true. The prosecutors, yes, they work in conjunction with law enforcement, but if you're not very familiar with how case numbers are assigned, how different things are processed, she's going through the mountains of evidence related to the case, and they're all filed under that same ID number. There's another case ID number, and typically they start out with the year. So you may have case number 2113026, and the other ones were brought in 24, so it may be 2400192. And again, it can be that random. Case numbers are assigned in order, again, depending on the size of the agency, first two of the year. Yeah. I think yesterday I ran case number 2413,000 and too damn many. But anyway, this conflicts with the testimony of Corporal Hancock, who said that the Special Prosecutor Morrissey decided to separately file this evidence apart from the evidence of Rust. Now, I have a question there because Morrissey would not have really decided how to put case numbers and stuff on things. That would be the lieutenant. That might be the lab girl. I don't know about if Morrissey would have filed it, in my opinion. Additionally, Special Prosecutor Morrissey acknowledged that CST Papel provided false testimony when, testified. You agree with me with the testimony under oath was false? Morrissey said what part of her testimony was false? That she said the rounds don't look anything like the rounds of the set. Miss Morrissey said, I agree with you, and I didn't realize that there were the rounds that look like that. Again, they collected piles and piles of bullets. You go through the evidence list, and you'll realize that they had piles of rounds. Anything that's brought a month later, 2 years later, Long story short, the analysis comes back. The assertion of a Brady violation is an allegation of prosecutorial misconduct. In order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, that the evidence was favorable to the accused, and or material to the defense. Well, okay, let's say she suppressed it. Totally. Was the evidence favorable to the accused? the fact that there were other rounds similar that okay, what was he accused of? He wasn't accused of anything due to the source, origin, or manufacturing of the ammunition. So, yeah, was it material to the defense? What were they going to argue? That he made the bullets? That he didn't make the again, I swear again, we come back to I agree with what Carrie Morrissey said. First element provides proof the prosecution suppressed or withheld the evidence. It does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. Basically says that it just says they didn't get it. Whether you deliberately did it, accidentally did it, forgottedly did it, you know, you did it because it was your dog's birthday and you were busy that day and didn't. You don't even have to do it in bad faith. You just have to do it. So, yes, I will give you the fact that she suppressed the evidence. She didn't turn it over. That's a fact. That's not a judgment call. You know, the second element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory, meaning can it impeach another witness or can it exculpate, meaning prove that you didn't do something? Well, impeachable, maybe, but exculpatory, I don't know. What we have here, Mary says, just my opinion, but I think that Alex brought the live ammo and intended to do what he did. Only he would know why. Like I said, just my opinion. Okay. I can't say that that's wrong because again, it's your opinion. Um, I will say that his name is Alec, not Alex. So right there, I'm gonna sort of gig you on your opinion. Um, love you, dear. Mean it. On the other side of that, I don't know, what he would have to gain by going through all this. PR for his movie, maybe. Would you kill a human being for that? Was, Helena Hutchins that much of a problem to you that you wanted her dead? I mean, honestly, it's turned him into a pariah in society. I mean, again, whether he knows that or not, you know, it's turned him into he used to be the one who went on Saturday Night Live and made a mockery of everyone else. Now we see, people coming out saying, yeah, I stand behind Alec Baldwin 100% because it's kind of dangerous to stand in front of him if he's got a gun in his hand. He's become a joke. So I don't know. Not to mention, I'm sure, getting charged was the least of his concerns, but perhaps. Love to hear what you would think or give me an idea, motive or just PR or the tragedy, trying to do his own little Brandon Crow tragedy or Brandon Lee Crow tragedy thing. But getting back to this, the second Brady element is whether the suppressed evidence is favorable either in an impeachment or exculpatory. Evidence is material only if there's a reasonable probability that the evidence had been disclosed to the defense, that had the evidence been disclosed to the defense, the result of the proceeding would have been different. We have here, what now? Alec was playing Jack Ryan in real life. Remember, her dad was a Soviet subcommander. Interesting. Interesting. So I don't think Alec Baldwin would actually have the testicular fortitude to play Jack Ryan in real life or even in a High School Musical, but that's me. But again, evidence is material under Brady. If there's a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Brady requires us to look at the entire trial and determine whether or not the defendant's conviction was obtained by violating due process, whether his or her trial was tainted, I said taint, with the fundamental unfairness because certain evidence was not disclosed. Okay. Now, they never got to the defendant's the end of the trial because it cut out in the beginning of it. But on the other side of the coin, we sit here and we say that Scott, I'm familiar with Red October. I've actually read the books. But getting back to this, would the let's say she had turned over this evidence, would that change what he's accused of? The elements of the crime he's accused of are handling a gun in a reckless and careless manner, resulting in the death of someone else. Yeah, you didn't hear bullets or ammunition in there, did you? So this is Carrie Morrissey's appeal stating, okay, I see you made this decision. I don't agree with it, and here's why. Under New Mexico's application of Brady, while post trial discovery of evidence under Brady requires no reasonable probability that the result of the proceeding would have been different, discovery of evidence during the trial result requires an evaluation of whether or not the late tender or the late disclosure has impeded the effective use of evidence in such a way that impacts the fairness or the fundamental fairness of the proceedings. Did this change the fairness of his proceedings because he didn't know about these other trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated. Courts must evaluate in considerations in Harper, culpability, prejudice, and lesser sanctions when deciding what to impose for discovery violations. And she goes on and talks about the sanctions here. One of the big ones is prejudice must be more than speculative. The party claiming prejudice must prove prejudice. It's not enough to say, well, this was prejudice against our client. How? Why? When discovery has been produced late, the prejudice does not accrue unless the evidence is material and the disclosure is so late. Remember, this was brought up the second day of trial. Jury was impaneled on the 9th. Trial began on the 10th. They were dealing with this on the afternoon of the 11th. So the evidence is so late that it undermines the defendant's preparation for trial. A court has the discretion to impose sanctions for a violation of discovery order that results in a prejudice to the opposing party. The trial court should seek to apply sanctions. As stated, in order to establish Brady, the defendant must show A, the prosecution suppressed it, even if Kerry stipulates to that and says, yeah, okay, fine, I suppressed it. But was the evidence favorable and was it material to the defense? All three prongs have to be satisfied. For the prosecution suppressed evidence, testimonies from multiple witnesses established the prosecution didn't provide the ammunition. The related report and the camera footage, everything, say she made a deliberate decision to place it in a non-rust investigative case number. Okay. The court concludes that the prosecution did suppress the evidence. Secondly, the suppressed evidence is favorable to the accused. The suppressed evidence is first favorable impeachment evidence and potentially exculpatory. For instance, the suppressed evidence was used as impeachment evidence. You know, I don't see, where this comes in. A testimony regarding the witness's lack of knowledge due to lack of further testing about whether or not they had ammunition that matched the ammunition that killed Miss Hutchins. In addition, the evidence is potentially exculpatory. For example, evidence regarding the source of a live round that killed Miss Hutchins and additional information concerning how that live round arrived on the rust set may affect the jury's calculus of proximate cause and negligence by a third person. The court concluded that the suppressed evidence was favorable to the accused. The suppressed evidence has to be material. Has impeded the effective use of evidence in such a way as it impacts the fundamental fairness. They asked the state to forensically analyze the Teskey supplied ammunition as the state had done with other units of ammunition. The court agreed with the defendant that had the defendant had access to the ammunition before the third day of trial, it could have altered their approach to preparation for the trial and trial itself. Really? I don't see how that would have done it. The court finds and concludes the defendant established a Brady violation which amounts to prosecutorial misconduct. The allegation of assertion of a Brady violation basically got the trial thrown out. Now, do I agree with that? Of course not. I made that pretty clear. I think that had there been something else or some other information or some other connection to it, yeah, maybe. But the purported mistaken belief by prosecutor Morrissey as to the physical characteristics of the ammunition due to at least lack of reasonable due diligence is no excuse for the state to suppress evidence. They've gone through, and as I keep on hitting, and I know I beat the dead horse in here sometimes, and I'm sorry, he was not accused of supplying the bullets. He was not accused of making the bullets. The source, the characteristics, the color of the primer of the casing had nothing to do with was your booger hook on that bang switch. That gentleman we saw on that other video, I promise you, the source and the company that made the bullets in that revolver, and whether they were all mix and match or whether they were jacketed hollow point or full metal jacket or wad cutter, semi wad cutter, does not affect the fact that the guy had the camera cocked and finger where it shouldn't be, kind of thing. Yeah. Where the bullets came from or nothing. He was grossly negligent handling a firearm and it resulted in someone dying. Carrie Morrissey went through and she made a pretty compelling case on this, in my opinion. I think that her argument, her appeal, it was not an emotional base. It was very much, this is what the court ruled. And I really think when the court looks at it, even if you stipulate to the first part of, yeah, I maybe suppressed something, but it wasn't anything that I should be gigged for suppressing. It wasn't anything that really, I'll admit I didn't turn it over. Never argued that point. But it was immaterial to the charges in the case. So, it's like, yeah, if you're getting charged with drunk driving and they say, yeah, that you also cut high school when you were like 17, you cut class. I don't think that's related to the drunk driving. It's same person, but there's no other relation there. A mistrial, is not would not be based on manifest necessity or jeopardy. You know, I see that again, they gave it out as a mistrial and she appealed it. From that standpoint, you know, she tried to do her best to take her chicken shit and make something out of it, at least fertilizer. Well, she asked for leave to represent the case, basically to uh, come back with an appeal. Well, as of 2 days ago, and now we're getting to something a little bit more current, she has dropped her notice of appeal. Now, why she did, I don't know. We can get into that discussion. I think she kind of got the legs possibly pulled out from under her by the prosecutor. Because remember, she was the special prosecutor brought in by the DA, and she was like their sort of covering. I think she's gotten her special prosecutorship pulled out from under her, and that may be why this happened. This was filed December 23rd of this year. Again, same case caption above. She was killed. Yes, Helena Hutchins was killed. The charges were pursued after discovery of evidence. 6 rounds were found on the movie set in November 21. None of this had, goes all the way through here and, talks about here where, um, see, March 6th, the same day that Gutierrez was convicted, Troy Teskey turned over 23 rounds of ammunition. 3 of these had the same characteristics as live rounds on the set of Rust. None of the ammunition turned over by Mr. Teskey was present on the set or even in the state of New Mexico prior to the death. Now remember, this is Carrie Morrissey. We talked about her appeal. She made her case on the appeal. This is her saying, nah, we're going to withdraw the appeal. But instead of it being, notice of intent to dismiss our appeal, no, this is a 5-page screed on why her appeal was right, but she's not doing it anyway. Which makes me think the rug got pulled out from under her, and instead of just walking away, she wanted to walk away with a little bit of a single finger victory salute in the rearview mirror. 3 of these rounds had the same characteristics. Detective Hancock with the sheriff's office made several requests for an interview of Teskey to determine any relevance and materiality of the ammunition. Her request went unanswered. 45 ammunition possessing the same characteristics of the 3 rounds presented by Troy Teskey are regularly available for purchase at retail stores that sell ammunition for firearms. That's an interesting little thing there. These bullets could have potentially, if that statement's correct, which I think it would be, could have been bought at a retail store a year after Helena Hutchins was shot. There's no solid connection between the ammunition. Yeah, they look the same. If I went and bought ammunition today of the same brand, model, make of something that I bought a year ago, and you looked at them, would they be the same? Yeah. Now, there may be slight differences in the powder and the chemical, but from the naked eye, they'd all look the same. Yeah. Personnel of the sheriff's office were aware of 3 of the ammunition provided by Troy Teskey had the same characteristics of the live rounds from Rust. No one from the sheriff's department notified undersigned counsel or anyone in the prosecution team of the characteristics of the 3 rounds at any point. As a result, the ammunition was never disclosed to the defense. Judge Marlo Summer sentenced Hannah Reed for conviction. You and you alone stood between a safe and a lethal weapon. The statement was made after an indictment of Mr. Baldwin by the grand jury, and Judge Summer was assigned to preside over the criminal case against Mr. Baldwin. The statement by Judge Marlowe was made with the full knowledge that Mr. Baldwin was also charged for using the firearm in a lethal manner. Judge Summer denied the state's request to compel the testimony of Hannah Reed in Alec Baldwin's trial. Gee, that would have been an interesting one, don't you think? She could have compelled her testimony. Didn't do it. That, I won't say it hurt the state's case, but it sure as hell didn't help. Alrighty. Mr. Scott, thank you all for joining us. I appreciate you coming out tonight, sir. We'll try to do one a little bit earlier for you next time. I'm going to probably be doing another live stream tomorrow night, either here or somewhere on the other channel. I'm not sure on my topic yet. I've got 2 or 3 that I'm going to be researching tonight. And I will even try to do it earlier for you since, the Beanie Boy's away. I'll try to go ahead and I'll try to fill his void a little bit. Yeah. Not like his new friends won't fill his void for him. But anyway. We go on. The state contends the ammunition was not material to the case against Alec Baldwin, as it was unconnected to the reckless manner in which he handled the firearm at the time of the shooting. The state further contends that the defense knew about the ammunition well in advance of trial, a fact that the defense has not disputed or acknowledged, and therefore they were not disadvantaged by the late disclosure. This is a big one. They knew about it. They were not hurt by the lack of disclosure if you knew about it anyway. You knew about it enough to bring it up on the second or third day of trial. So the fact that no one told you, Carrie Morrissey never told you about that stuff that you knew about, and you were hurt because she didn't tell you about it, but you knew about it. There's some days I'm glad I'm not a lawyer because this stuff would not pass the bullshit test in the real world. During an on-the-record sidebar, the special prosecutor requested the court determine when the defense team became aware of the existence of the ammunition, as this was critical to the court's analysis. Okay. They're saying, well, she never told us about the ammunition, so you've got to throw it out. Carrie Morrissey looked at the judge and says, Your Honor, ask them under oath when they learned about this. They're throwing the case out because I didn't tell them about this. Ask them how they found out about it when they learned about it. Did Troy Teskey do it? Call up Phil Reed and Alec Baldwin and say, hey, I just threw a monkey wrench in the case against your kid, brother. You owe me one, boy. There's a question there. And again, even if Thel put him up to it, Thel, I get it. You're trying to take care of your problem child, brother. I get it, totally. So the court declined to make an inquiry. They declined to ask when and how they found out about this. Despite the fact that they're proven to be aware of it, they're throwing the case out because she didn't tell them about something they already knew. She asked them to ask the judge to ask them under oath how they knew about it. Judge wouldn't do it. Ooh, that's questionable. That's like, I can't say judicial misconduct, but that's the next logical question. You're all upset because she didn't tell you about this, but you knew about it, so what's the deal? Despite the evidence that they were aware of the ammunition, let's see. The case against Mr. Baldwin was dismissed with prejudice for all the following reasons. An interested party, Troy Teskey, a good friend of Hannah's father, provided 3 rounds of ammunition in a bag of 20 plus more than 2 years after the date of the shooting. He previously disavowed possessing the ammunition and previously provided 2 photos of the ammunition in his possession that did not depict the ammunition he provided. The ammunition, identical to the rounds of ammunition that were provided, can be purchased anywhere. The ammunition was never disclosed to the defense, but there are clear indications that well before the trial, the defense knew of the existence of the ammunition, knew it had been turned over to the sheriff's office, knew that 3 of the rounds were... How'd they know that, I wonder? Because Carrie Morrissey, remember, she's getting smacked on the wrist for not telling them this. The defense implied to the court during arguments that they were unaware of the ammunition that they brought up the day before. Again, defense attorneys have to play by a different set of rules than prosecutors. Prosecutors, the idea is justice. If a prosecutor starts thinking that the person they're going after is innocent, they have to stop. It's not about wins and losses for them. It's about the equal hand of Lady Justice. You know, the blind chick with the scales out in front of the courthouse. Defense attorneys win at all costs. If their client gets off, they win. They did the right thing. Whether or not, again, they don't get ruled innocent. They just get ruled, you haven't been proven guilty. During the pendency of the case, the course granted, and again, they talk about page limits here. Basically, Carrie makes the case that when there were page limits placed on motions, their side was allowed to exceed the page limits by the judge repeatedly. When she asked for permission to exceed the page limits, she was told, hell no, you're evil. That's, again, kind of sketchy. Okay. Your football team on Sunday is not allowed to hold when they're on offense. The other team, yeah, they're going to grab some jerseys and life's okay. Why aren't we all playing by the same rules? The Office of the Attorney General notified the undersigned counsel the AG would dismiss the appellate efforts if the reviewing court did not recommend summary reversal. Under New Mexico law, only the AG is vetted with prosecutorial power to prosecute and defend criminal appeals in the higher courts. At the simplest level, this is Carrie Morrissey stating, look, I'm withdrawing, she signed it, sealed it, delivered it, filed via Odyssey December 23rd. She made some good points. She made some fair points. I don't know if she's right. I don't know if she's wrong. I can't say that. What I can say is the prosecution did not notify the defense as they should have. The defense has proven they knew about it all along. That was obvious. The prosecution asked the judge to ask them how they knew about this all along. She wouldn't do it. The prosecution asked to exceed a number of pages in motions, page limitations. Was told no. The defense was told share. Now, interesting, when the defense has a dream team of lawyers and the prosecution has Carrie Morrissey and like one other and an assistant, they are drafting motions in excess of the limits that she and her team are having to respond to repeatedly. And they're allowed to go over the limits. She's not. They're being allowed to bury her in paperwork. She's being told to respect page limitations. Judge Summer, I can't say was wrong, bad, evil. I'm not saying that Alec cut her a check and she got a summer house out of it. I don't know. I can't make that assertion. Maybe she's an Alec Baldwin fan. Maybe she just is a very, very big pro rights of the accused fan and wants to give the accused the benefit of the doubt. And that can be good in our justice system. On the other side of the coin, when this evidence that the defense was all aware of gets brought up on like the second, third day of trial, or second day of trial, because first day was just jury selection, so second day of trial, they knew all about it. But they're claiming they didn't. Yeah. That would be like me saying, I didn't know anything about the EMS patch up on the wall behind my head over here. I never knew there was an EMS patch right there. Gee, why didn't someone tell me? None of y'all told me about the Islanders jersey up over here. Really? How can I claim ignorant of the Islanders jersey or the Swamp Rabbit sticker or any of that stuff when it's right in front of my face? I've got questions. It's very possible, but I don't say it's plausible, possible, whichever term you want to use. The Troy tried to do Thal a solid and help his little girl out. It's very plausible that Carrie Morrissey made a judgment call that was very reasonable under the circumstances. We've talked about it. This ammunition could have come from anywhere. It was not on the set and likely not in the state on the day of the shooting. It's not related to it. Yeah. It's kind of like somebody sitting there and saying, well, so and so must have robbed that store because, again, he lives near that store. Well, a lot of people live near that store. Well, he drives a red truck, and they said there was a red truck. Okay, maybe you're getting a little closer. Well, they said he was the right height and the right weight. Okay. And then all of a sudden, the prosecution finds out that the guy traded in his truck 2 days before the robbery and didn't have the red truck. That would be exculpatory. That would prove it. But if the guy says, no, I had an alibi, or I traded in my truck the week after because I didn't like the gas mileage it was getting, that would not be exculpatory. You make a judgment call as a prosecutor, as an attorney. I don't disagree with Carrie Morrissey's call, and I'm sad that she withdrew the appeal. I think her appeal was well-founded. I think it could have made a good case. And I think her taking a couple of shots at the judge in her decision to withdraw the appeal I get it. She's frustrated. This would have been a big win for her as a prosecutor. It also, I think, would have sent a very, very good message about personal accountability. Yes, no one's above the law, Alec. No one is above the law. Yeah, you're famous. I get it. Yeah, you could buy and sell me 40, 50 times over. But you did something wrong. Somebody died. There's a price to pay. Now, I said from the beginning, I don't want to see Alec Baldwin go to prison. I wanted to see him do a bunch of community service, making gun safety videos. I've said that all along. With his connections in the industry and his ability to get studio and filming and editors and soundstage stuff, talking about how important those 4 rules are. Let's have Alec Baldwin do videos that we can use as instructors that we get free access to. He puts the work in, does the community service. That would be a win-win for society. Yeah, but I guess what's good for society, maybe not the best if you're Alec Baldwin. You may have a little bit of a special one there. May have a little bit of a pass on that. All righty, that's all I've got for tonight, folks. I definitely appreciate you coming out. Please, if you get a chance, check out one of our favorite sponsors. It is Blackout Coffee. They have been really good to us. We do have a special promo code with them, Gun Club, and that promo code is good for 20% off your first order. They've got all these wonderful flavors: Nutty Dad's Java, Irish Cream, Blueberry Crumble, Cinnamon French Toast, Butterscotch Toffee, Chocolate Cherry. Yeah, and all these wonderful Pro 2A blends. This again, no compromise. That's the GOA. They've got one over here from SAF, the Second Amendment Foundation. They've got here from 2A Guns and Gadgets. Why we support Blackout? They support us. They support the 2A community. They donate money from each sale of all these wonderful blends to 2A organizations. Remember, we got constitutional carry. We got the Bruin decision. We got Cargill v. Garland. And we've got a lot of other really cool decisions going through the courts. And the agencies and the groups that are bringing these 2A suits to fight for our rights, they get not only caffeinated, but supported financially through Blackout. And that's why, again, we'll support the brands that support the second. I'm a big believer in it. And I will also say it is damn good coffee. So, with that being said, I want to give them a shout out tonight because we always support our friends at Blackout Coffee. They do great things for us. I haven't seen this video in a while, and I do kind of enjoy it and appreciate it. So let's have a close out here. A little bit of a change of pace. Where is it? I thought I had it in here. I may have taken it out. If I did, boy, I did a dumb thing. I did a very dumb thing. Yeah. Okay. I found it. Folks, be smart, be safe. I will see you again, quite likely tomorrow night on this channel or the other. Bye.
Up and down, counting out, smiling through the taste of blood in my own mouth. I got bruises and broken bones, but they don't know I ain't in this ring alone. I'm a fighter. No one can say that I'm a running hider. I was born to be do or dyer, make it righter. Don't throw that towel just yet. Don't cash in that last bet. 'Cause I hit harder when I'm tired. I'm a fighter. I get back up. That's what I do. I didn't soldier on this far just to lose. So take your shot. Is that all you got? I'm a fighter. No one can say that I'm a running hider. I was born to be a do-or-dyer, a make-it-righter. Don't throw that towel just yet. Don't cash in that last bet. 'Cause I hit harder when I'm tired. Yeah, I'm a fighter. Oh, no one can keep me down. They didn't know, but they know now. That I'm a fighter. No one can say that I'm a running hider. Don't cash in that last bet. Don't throw that towel just yet. I'm a fighter.